Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with email and email addresses, specifically as they relate to sending notice per the contract. So in the GAR contract, it does state that all notices given hereunder shall be in writing, legible and signed by the party giving the notice. It further goes on to say that notices shall be delivered in person by courier or overnight delivery service or certified or registered U.S. mail, or by email or fax, and that the person who delivers the notice may be sending the written notice signed by the party might be someone other than the party. So the delivery of the notice doesn't have to be the person that signs the notice. The person that signs the notice obviously must be one of the essential parties to the contract, that is either the buyer or the seller. But here's the thing, it further goes on to say, now we're just going to talk specifically about email. I did another video regarding notice in general. I'll put the description in, a link in the description below to that previous video on notice. But we're specifically talking about email and some issues that you as an agent need to avoid with respect to the contract to protect the best interest of your clients. So basically what it says when it talks about the delivery of the notice, it says that notice in the GAR contract, and I am on paragraph C1 in the GAR purchase and sale agreement. In the RE forms contract, all of this information is spelled out in the notice section in the standard terms. And basically it says a notice to a party shall be deemed to have been delivered and received upon the earliest of the following. And where it talks about in the case of delivery electronically, which would be email, on the date and time the written notice is electronically sent to an email address or fax number of the party herein, or subsequently provided by the party following the notice provisions herein. Notice to a party shall not be effective unless the written notice is sent to an address, fax number, or email address of the party set forth herein, or subsequently provided to the party following the notice provisions herein. Okay, so what that means, you guys as agents, you need to be very careful. Notice must be sent to an email address as provided herein. So what does that mean? That means the email address that is on the signature page of the purchase and sale agreement is the only email address that will suffice for legal terms of notice. If another email address is going to be used, then the parties must send notice following the terms of notice of that new email address. So here's where you have to be careful. Let's say you've done a co-op deal with an agent before, or let's say that on the purchase and sale agreement, it is their broker's email address that auto-populates on the purchase and sale agreement. Or they have one email address on the purchase and sale agreement, but you send, let's say you're the buyer's agent and you send an, you're the listing agent and, or let's say you're the buyer's agent, you send an offer, or regardless of which agent you are, which side you represent, if you receive an email address from your co-op agent and you end up communicating using that email address, if that email address is not the same email as printed on the purchase and sale agreement, then you may not use that email address for notice, for example, for terminating a contract. Or if there are two listing agents, if there's a listing agent and a co-listing agent, and one of the listing agent's email address is printed on the purchase and sale agreement, but you end up actually emailing and communicating by email with the other agent, then again, if the buyer's agent, for example, is going to terminate the contract and send that notice of termination, That notice is only deemed valid if it is sent to the email address that is on the purchase and sale agreement. So what would you do if there are multiple email addresses? So for example, let's say there are more than one listing agents, or let's say that the co-op agent with whom you're working has two email addresses. Let's say, for example, that the brokerage where they work gives them a formal email address, and that's the one that prints on the purchase and sale agreement, but they end up using those. So for example, let's say my email address, if I was actually practicing, my email address that would print on the purchase and sale agreement would be dana@maximumonerealty.com. But in practice, I actually use the email address dana@thehousesoldname.com. Well, in actual communication with the other agent, if I use my cutesy email address, but that's not what printed on the purchase and sale agreement, then notice would have to be sent to the one that printed on the purchase and sale agreement. Again, you can change email addresses, but you have to use the formal notice provisions as provided for in order to change it. And in the RE Forms contract, it says you must wait 5 banking days to change that email address. GAR has a special stipulation for email to be sent to multiple addresses. So it's special stipulation 263, and it states, all parties agree that email notices sent to blank, and you're going to put in, the buyer or the seller, shall be sent to both of the following email addresses. And you would put in 2 email addresses. In my example, you would put dana@maximumonerealty.com and dana@thehouseholdname.net. Whatever those 2 email addresses are that agent is using. Provided that notice is sent to both email addresses, notice shall be deemed given when it is first received at either of the above addresses. So again, that would also be a great special stipulation to use if there are multiple buyer's agents or multiple listing agents working with the buyer or the seller. Now, it does say that as with notice delivered, parties must take great care to send notice to the email address specifically provided in the GAR contract. This is because notice can be delivered via email if sent to the email address identified in the contract. So for example, let's say an agent provides personal email address, but the selling agent who's worked with the listing agent before had another email address saved in their actual address book. Let's say by mistake, the selling agent sends the notice to the email address that they had saved in their address book rather than the listing agent's email address that was provided in the contract. Since the notice was not delivered to the email address identified in the contract, the notice is not valid even though it went to that other email address with which you had been communicating. So if you are using an email address that again, that you use, that would be just as a courtesy, but for purposes of notice, you need to check it out, what's in the purchase and sale agreement. Now, if a brokerage is working with a buyer or a seller as a customer, that means they don't have a listing agreement signed with the seller, and they don't have a buyer brokerage agreement signed with the buyer. So they're working with the public as a customer, not as a client. So they would have an authorization show and list of property signed with the seller or a customer acknowledgement signed with the buyer. If that's the situation, then notice to the broker does not, or to the listing agent or to the agents, does not serve as notice to the party for purposes of notice. And again, that is spelled out in the instructions, as I always say if you take my contracts classes, in the purchase and sale agreement. And in the GAR contract, that is listed in paragraph C3C, when brokers is authorized to accept notice for the client. And basically, if you are working with the public as a customer, if you are working with the public in a dual agency situation, then the notice for purposes of the contract must actually be sent to the party. And that is why in the on the signature page, there is a blank space to fill out the email address. You can do email address or fax, or a physical address. Telephone does not suffice as notice for the purposes of our contracts. Telephone communication, which would also include text, because text is sent via a telephone, that is just for convenience factors, but does not serve as notice. So again, be very, very cautious and very diligent about what email addresses print on the purchase and sale agreements and what email addresses you are actually using in practice. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.